you, of course, have the slides in your booklet. You may, of course, want to take some notes, but the reality is the slides are fairly detailed, as you may have seen if you've had a look. So it may be of more value to actually sort of focus on the discussion rather than scribble notes, but I do recognize everybody learns differently, and sometimes people learn better if they're scribbling while they function. We're not going to go through the agenda, but just so you know, it's in the slides. Bear in mind, the agenda is just a rough outline. We want this to be as interactive as we can be. So by all means, feel free, jump in, ask a question, make a comment. At some point, we may cut you off, either because you've asked something that we're going to get to later on, or because we're getting too focused and maybe bogged down into the detail of something. But Chris and I will be happy to deal with those kinds of things during the breaks. What we're going to talk about is a basic understanding of IP rights, which Chris is going to provide for you, and I appreciate many of you will already have that. We're going to talk about the structural and technical aspects of license agreements and understanding them for the purpose of both negotiating them and drafting. But this is not a pure contractual drafting course, so we're not going to go through drafting itself. And we're not going to discuss compulsory licensing provided by law under the Patent Act or the Copyright Act, for example. Session 1, which is this morning, we're going to cover these topics. I won't dwell on these. And then it lists the various sessions. When we say sessions, a morning or afternoon session, so there are 4 in the course. So you'll get a sense, if you flip through these slides, as to how everything unfolds. For the most part, and there are exceptions, we will follow the way in which the provisions end up being laid out in a license agreement, but there are a couple of exceptions to that. So I'm going to speak for a few minutes on what a license is, because people often don't truly understand what a license is and therefore what a license agreement does. A license is a business relationship, and licensing is on the increase for a variety of reasons. It's because the owner of intellectual property is not always the most suitable person to use it or commercialize it. The owner may have product A, but the technology or the rights expand or also apply to product B. The owner doesn't make or sell product B, or doesn't function even with product A in a particular territory. It could be a product, could also be a service. The owner may, when I say the owner of the intellectual property may not have the capital or the interest or the facilities to exploit that technology. So a license is a way to further exploit the same asset without investing, but by allowing other people to exploit the right, generate revenue, and share the revenue back with the licensor or the owner. There are a variety of reasons why licensing is increased. There's more global competition. There's a better recognition of IP rights, or more broadly, intellectual capital by business people. There's a declining product life cycle, which means products become obsolete more quickly. All we have to do is look at the cell phone market, for example. A few months is a lifetime. And with increased cost of R&D and the time R&D takes to get a product to market, if somebody else has the technology, if somebody else has the branding that somebody who wants to get a product to market can license, that will get them to market faster or before they miss the product curve. Large players in the market pose a problem. So for the small startup, it's very hard to compete with large players, but it's easier for the small startup perhaps to license those rights to a major player. There's also increased patent activity where more and more people are getting patents, so the patent landscape is so complicated that it becomes harder for people to navigate that, and with the risk of, particularly in the U.S., lawsuits and even treble damages, although that's been slightly modified by recent law, but high patent awards, it's often better to get the product into or the technology into the hands of somebody who's already in the market and can better exploit it.